My name is Ken Burgess. I am a healthcare attorney with Poyner Spruill law firm in Raleigh and have been involved in this state with developing our end-of-life laws since about 2006. I know you have some questions, so let's get to them.
What does U.S. federal law say about my advanced care planning?
Federal law, meaning it covers every state in the U.S. and all U.S. territories, says that every citizen of this country has the right to make advance directives that express directly to their healthcare providers their wishes for end-of-life care and the right to name a third person to make choices for them when they can't make them or communicate them themselves. It also requires all major healthcare providers, hospitals, nursing homes, home health, and hospice to have policies and procedures explaining to you how they will carry out your end of life wishes.
Okay, let's say I'm not able to speak for myself and I have an advance directive and my family shows up in the hospital room and my friends show up and the doctor's there. Who really makes the decision?
So if you have a healthcare power of attorney, then the person you have named in that document will always be the decider. The only exception is if for some reason that person is not acting in your best interest and we can persuade the hospital or doctors of that. That may not be true, but generally, if you've named a person to speak for you, they will be the one with authority to speak for you.
I travel a lot for work. Is my advanced healthcare plan still relevant outside?
Generally speaking, if you have an advance directive, a living will, or a healthcare power of attorney that's valid in the state where you live, when you travel, other states will also honor it. In addition, if you have one of those documents that's valid under that state's law, then you'll always be okay. But generally, most states honor each other's living wills and healthcare powers of attorney if they're valid in the state where they were created.
Often do I update my documents? And what happens with my old documents if the law changes?
You should update your living will or healthcare power of attorney really only when one of two things happens. You have changed your mind about the choices you've already expressed. Often that happens after you have a serious change in your health condition. The second time is if you've named a person to speak for you in your healthcare power of attorney and you're not friends with them anymore, or maybe they've passed away or you just don't like them. You want to update the person who's speaking for you because that's a really, really important designation. If and when you do update your living will or your healthcare power of attorney, it's really important to obtain all copies you may have shared with your physician, your family, whomever, and destroy them. You can tear them up, you can burn them, you can write the word void, V-O-I-D, across them, whatever, to indicate that they are no longer any good. You don't want a later document that you've created to be replaced by one that was earlier and you revoked it and you just forgot to pull it out of circulation.